Welcome to Unit 2 of the Introduction to American Law course. In this unit, we will be discussing litigation. And specifically, in this first lesson, we're going to talk about the differences between civil procedure and litigation, bringing cases to different types of courts, and what that means for each specific court. So, let's hop into the basics of litigation versus civil procedure. Basically, in both cases, the authority behind the process is the government. So basically, in order for litigation and civil procedure to work, it relies upon the government to hold specific powers that make it work. In understanding the differences between litigation and civil procedure, basically, litigation is the mechanism that people formally use to resolve disputes, whereas civil procedure is the body of law created by the government that carries out litigation. So basically, they're very similar, but there's that slight difference where litigation is the process and civil procedure is the law that carries out the process. Now, in understanding litigation, it's important to understand why specifically people seek out litigation. And basically, that's what happens when people have disputes between each other and they can't settle them themselves. So when two people have an argument that involves maybe another person's property, but they can't settle this dispute between themselves, then they go to the court system and seek out litigation. In carrying out litigation, remember that civil procedure is the body of law that carries out that process. Then there are certain goals of civil procedure. One of them is to implement the laws that are already in place, meaning civil procedure should not create new laws that violate those already put in place. Also, civil procedure should be relatively fair to both parties. And finally, one goal of civil procedure is to be somewhat efficient. Although some cases may take years to resolve, then it's more efficient than retrying the same case over and over and over again for decades. Next, let's look into when a lawsuit is brought to court, what court should a lawyer bring it to, and that deals with the idea of jurisdiction. What jurisdiction is the authority to hear specific cases. And really, when we break it down, there are two main types of jurisdiction. And both of these jurisdictions need to be met in order for a court to hear a case. Meaning, a court must have both subject matter jurisdiction and personal jurisdiction in order to hear a case. Let's look at these one by one. First, there is subject matter jurisdiction. What that means is that a court has the power to hear a specific issue in a case. For instance, a court might be able to hear claims regarding breaches of contract, whereas another court might have the authority to hear criminal procedures. Courts do not always have the authority to hear all different kinds of cases. When we look into subject matter jurisdiction, we can break this type of jurisdiction down even further into general versus limited jurisdiction. General jurisdiction means that a court basically has the authority to hear all different issues regarding cases, or mostly all issues regarding different cases, whereas limited jurisdiction means that courts have very specific issues that they can hear. For instance, one court might be able to hear anything from divorce claims to homicide cases, whereas another court may only be able to deal with issues regarding family matters. When we look at subject matter jurisdiction in relation to the federal court system, then there are two main cases where the federal court system has subject matter jurisdiction. One of those cases is called federal question jurisdiction. This occurs when a specific case deals with a question of law on the national level as opposed to the state level. So for instance, if a case involves the freedom of speech, that would be a national issue, so it can be tried in a federal court. The other time that a federal court would have subject matter jurisdiction involves diversity jurisdiction. In this case, we have two people from different states who might have a dispute against each other. So because the court system does not want to favor one state over the other, then it is heard in a federal court as opposed to a state court. When this occurs, then normally there needs to be a certain amount of money at play here, because we don't want to bog down our federal courts with disputes over, say, someone didn't pay their half of lunch. Now that we've discussed subject matter jurisdiction, let's talk about personal jurisdiction. Personal jurisdiction is basically the power over the people in a specific case. So, for instance, a court in the state of Washington cannot try a case regarding two parties in Georgia. That would be a violation of personal jurisdiction. Or a state court in Oregon cannot try a case between two people from Michigan. Now, to make this a little bit more complex, in order to bring a lawsuit into the appropriate court, you have to also consider the two different court systems that exist. In the United States, we have two court systems that operate independently of each other and in the end operate together, and that those are the state system and the federal system of courts. The state system, basically each state has their own court system that handles issues within their own states, and then the federal court system handles more national issues. Basically how this works is according to this flowchart right here. So state trial courts operate independent from the federal court system, and then that leads up to appellate courts and then the state Supreme Court. While on the federal side, district courts operate up to appeals courts, and then in the end, at the top of the pyramid in both systems is the United States Supreme Court, which reigns over all courts regardless of state court or federal court in the entire country. There are some more courts that do not necessarily fit into these systems, and these courts are brought about to tackle very specific issues. So for instance, family courts, they just deal with solely family matters. So if there's an issue if there is an issue of custody between parents, then that issue would probably be resolved in a family court. In addition, there are courts of law and equity that deal with lawsuits in a little different way than typical courts. Courts of law and equity deal with lawsuits by issuing maybe injunctions as opposed to awarding cash settlements. Make sure to check out your notes for more details on what courts of law and equity do. So when we start talking about different kinds of courts and different court systems, it raises the question that do all court systems exercise the same law, or are there different sets of laws that apply in each court system? Really, what this comes down to is that normally each specific court applies its own law, meaning that a state court applies state laws and a federal court applies federal laws. However, there are exceptions to this rule, one being that if a state court is tackling an issue of federal law, then the state applies federal law to the case that it's hearing. In addition, when a federal court is hearing a case on the basis of diversity jurisdiction, remember diversity jurisdiction is when a federal court is hearing a state is hearing a case with people from two different states, then it would apply state law as opposed to federal law. And then the last exception is conflicts of law. What this means is that sometimes state law seems to contradict federal law. When a case like this comes up, there's no clear indication as to which law a court should abide by, so it basically gets to make its own decision. That judge or that jury gets to decide which law it would like to reign supreme. Finally, in this lesson, we will discuss the doctrine of removal. What removal is, basically, is that a case starts in a state court, and if this case has the power to move to the federal court based on subject matter jurisdiction, personal jurisdiction, maybe it discusses a federal question, which would mean federal question jurisdiction, or by diversity jurisdiction, which deals with individuals from different states, then a defendant can effectively remove a case to a federal court. What this means is that the case moves from a state court into a federal court. This does not have to occur in all those cases. However, that is the option of the defendant to remove a case from a state court into a federal court. So in this lesson, we discussed the differences between civil procedure and litigation. We discussed bringing cases to different types of courts based on jurisdiction and based on the different court systems. Make sure to check out your notes for more information on all of these topics that may not have been covered in this lesson.